Hello, everybody. I'm Professor Michael Epstein. I'm the director of the Amicus project at Southwestern Law School, and this is the latest in the series of Amicus project spotlights that we do from time to time, where a student discusses the Amicus brief that he or she took into the courts. It discusses the brief and discusses the case. And I know we have several people who are tuning in via Zoom, including practitioners. This is a CLE event. Pleased to state for 1 hour of CLE credit. I will just say that the Amicus project, very briefly, is now in, believe it or not, in its 10th year. Here at Southwestern. It's a pro bono outreach project in which students apply to take on an amicus brief in support of a party in a real pro bono case. It's kind of like real moot court. And we have done more than I can count at this point, cases over the last decade, including cases that are done by some of the people who are here with us today, both as former students and as our faculty supervisors. So I have here with us actually the first student in the Amicus project, who is now Professor Orly Ravid. Orly was also a supervisor in a subsequent case, and she's the supervisor in this case. We have here also one of the other signatories on the brief, faculty signatories, faculty emeritus Robert C. Lind. Robert Lind is really the founder, the creator, the builder of Southwestern's entertainment and media law program over decades, and it's great to have you here. I have another student who will be doing one of these spotlights in the future, Josh Kahn, and he's here with his supervisor, who is also a veteran Amicus project faculty supervisor, Warren Grimes. And I also want to welcome the students who are here in the room. The one person I left out is here on your screen. This is Christina Cavazos. Christina she completed successfully, and I really do say successfully, an amicus brief in support of Warner Chappell Music. In the case you see in the PowerPoint slide, Warner Chappell Music Incorporated versus Nealy. I say successfully because just last week, the Supreme Court announced that it would grant certiorari, and so now the case is moving on into the merits stage. But I want to turn it over now as quickly as I can to Christina, because she's going to give you a presentation about the case and specifically about the brief. And at whatever point that Professor Ravid or Professor Lind want to chime in, just remember that I think your mic may be working over there, but we'll repeat your question if you have a question. And then we'll have time at the end for folks here in the room and folks who are dialing in from home to do Q&A. So without further ado, here's Christina. Thank you.
Thank you. Hello, thank you very much for attending today. And first off, thank you to Professor Epstein, Professor Lind, and Professor Ravid for allowing me to take on this project.
Christina, you pin the mic on. Pin on, it'll be easier to hear you.
Oh. Okay. This was definitely a challenge, but I think that's the best thing about learning is you get to challenge yourself, and that's the way you get better. Taking on this brief, there was a lot. It was a culmination of everything you learn in law school, basically how you do your research, all your going back to 1L and remembering your laws brief a little bit, bringing out the blue book. So it definitely was a good refresher on all that, and just challenging in general, because you have your professors and your supervisors, but you are ultimately responsible for the bulk of the work. So we'll get right into this case. This case came about, the 11th Circuit had ruled in favor of Nealy, basically saying that the discovery rule, when discovery rules applied, the plaintiff could recover damages further back than the 3 years. And there was some contention with what has been said in Petrella, which at length was discussed that, damages were limited to 3 years. And it was in contention with the second court's ruling in Chappell. And so that's kind of how Warner decided that they were going to appeal, up to the Supreme Court, because this has been a long-standing split, and hopefully, like, the Supreme Court would weigh in on it. So the question here was basically, does the statute of limitations limit retrospective relief to only 3 years of damages?
Maybe we should, just so everyone understands, when we say Petrella, it was a copyright infringement case involving a major motion picture and a major studio that went all the way up to the Supreme Court. And actually, we filed this project filed a brief arguing that in that case, the issue is, does latches, the equitable defense of latches, apply to bar a claim after 3 years that was filed after 3 years, and the Supreme Court held no. And I just want to give the context.
Right. I should also say that the student who was on that brief was poorly reviewed, and the supervisor on that brief was Robert Lynn. So and Drew Pruitt as well was on this brief. It was the first Amicus project case that went to the Supreme Court. So
kind of comes full circle. So the facts of this case was the plaintiff, Sherman Nealy, had incorporated Music Specialist Inc. Him and his partner, Tony Butler, created multiple musical compositions, which were issued between the 83 and 86. In 86, Music Specialist became dissolved, but didn't cease doing business till 89. The plaintiff, Nealy, ended up going to jail, serving a time sentence for cocaine possession, and was in jail until 2008. During that time, Butler had created his own company called 321 Music and had began licensing some of those compositions. So there is a contention there. And then when Nealy was released, he found out that there was a third party that had music. The guy's name was Crane. And he told him, he said something to him. He's like, oh, you have my music. But he failed to do anything. He didn't take any action, didn't file any litigation or anything like that. In the meantime, Butler had began litigation with Warner Chappell and a few other third parties, Crane included. And this was before Nealy went back to serve his second sentence between the years of 2012 and 2015. When Nealy was released in 2016, he was informed by a former MSI associate of Butler's litigation and that the music had been licensed. And so Nealy waited another 3 years, almost from 2016 to like 2018, to file a suit, almost 3 years. And so claiming that he owned the music and that the license that Warner and the other third parties have been using were all invalid. So the district court ended up certifying, they denied Warner's appeal for summary judgment, saying that there was an issue on when the claim actually accrued. And then they also certified for interlocutory appeal whether or not the damages were going to be limited to the 3-year look-back period. On appeal, the 11th Circuit received the case, and they determined that under the discovery rule, the damages were not limited to a 3-year look-back period. And so Warner Chappell then decided to appeal that. So moving into the arguments, since this was a pet stage brief, the main idea of the brief is to get the court to take up the case. So it's not arguing like the merits really on should it be limited or not, but like why the court needs to ultimately hear this case. So my first argument was basically going through the discovery rule, like, should the discovery rule be applicable? And there has been contention throughout the course history of whether or not a discovery rule is applicable. And I analogize to TRW versus Andrews that, you know, the Supreme Court has stated that there is no general discovery rule. Like, usually the statutes like account for a discovery rule. And the facts in TRW were somewhat similar to like what you would see in most copyright cases. You had a plaintiff whose information had been given out, and she didn't discover that her information had been improperly given out until a few years later. But part of her claim was barred by the 2-year statute of limitations. And so she could only bring 2 of the claims. And they ruled, you know, like, there's no discovery rule in the statute, therefore it was barred. And my second argument was that discovery rule has really only applied, or the Supreme Court has really only applied discovery rule in very limited scope of cases, usually dealing with cases of fraudulent concealment or cases that deal with like latent medical disease, things that you couldn't readily like discover. Copyright itself, like usually infringement, somebody's putting that work out there, whether they're publishing it on Spotify or on, you know, YouTube or whatever they're doing, like it is out there in the public. So it is something that is readily able to be discovered. And so that was my second argument. And then the other last argument in the first section was whether or not was that Petrella actually led to more confusion rather than more clarity. Since Petrella, there has been a lot of contention, as we can see by now, this deepening circuit split over whether or not, you know, the statute does limit the damages to 3 years. In Petrella, they specifically, in a footnote, stated that the court is not going to like weigh in on the discovery rule. And some courts have taken Petrella, such as the Second Circuit, and said, no, the Supreme Court has said it's limited to 3 years. But then other courts like the 9th and the 11th have said, no, all of that discussion was just dicta, and it's not limited to 3 years. And the court specifically said it's not going to weigh in on the discovery rule. Therefore, like, it's still open and we're going to go with our precedent. My second section of my brief, I discussed the legislative history. I went back through the Senate reports when they were getting ready to create the statute of limitations. And there was a lot of discussion in the reports about whether or not to add a discovery rule, specifically like for cases of fraudulent concealment. And ultimately they decided not to add one because of the nature of art and it is so public. They didn't feel it was going to be necessary. And even the way that the publishing industry was then, they ultimately decided against it. Additionally, when they went to revise the Copyright Act, you know, they discussed it once again. It was even brought up that there was a confusion, and the language could be confusing whether or not there was a discovery rule applied, but ultimately, again, they decided not to revise and add a discovery rule. And then the very last part of my arguments was essentially there's a really big circuit split. And even before Petrella, there was still contention whether or not there was a 3-year limit on damages. Some courts have said yes, like discovery rules applies, but we're only going to limit damages to 3 years, and some have said no, like they can recover all the way back to the infringement. So it's been a long-standing issue, and this is the perfect case for the court to weigh in and, you know, one, discuss whether or not I think the discovery rule applies, but also like how that impacts like damages. And so, like Professor Epstein has mentioned, the court did grant cert, so they will be hearing this case, and they are going to determine whether under the discovery rule, if they can recover damages more than 3 years for the lawsuit. So
with any luck, they'll ask you to to speak at oral argument side, though, that never has happened before. I
Well,
can
we
only
have had-
pray for it.
We have had people actually invited to sit at oral arguments at the Supreme Court. But yes, it's maybe too much to expect that you would have a chance, especially as a non-lawyer.
Yeah.
I'm good. I'll watch. Any questions?
So yeah, so say your name, if you don't
My
mind.
name's Delise.
Delise?
Delise Day. I'm her friend and classmate. I know you're writing the brief that's gonna go forward after that, after there's a congress. So I figured, you know how you're gonna formulate your arguments for the next brief?
Not yet.
That's a great question. So the question was, the question was, do we know has she formulated her arguments for the merit stage brief? And well, you heard her answer.
When because I have been thinking about it too, because I'm meant to supervise. So first of all, I think it's worth noting that, we didn't immediately jump to taking this side of the argument. I remember when I wrote the one, well, the first one, the Ninth Circuit one was easy, but the second one, the Petrella case, I remember initially having a little bit of a hard time being on the side of the studio. I just tend to be more plaintiff, little guy oriented. But in thinking it through, it made a lot of sense, the arguments that this school made, and in fact, they prevailed. And Ruth Ginsburg, authored the majority opinion in that Petrella case. And then here, I have to say that the research board, arguing to take up cert was easy. The circuit split was real. It created a lot of confusion. It created an inability to predict results. And in fact, the record industry also weighed in on I want to say not partisan, like not taking a side, but rather just putting forth a need to make a clear standard across the circuits. So that was, I think, more clear how to proceed, even though you did make a merits argument in your amicus brief. When you started to talk about the legislative history and how really the statute was clear, it considered and then declined to have any discovery rule or to not have a strict statute of limitations. I know that there's a plaintiff's firm. I won't mention the name, but it's very reputable and famous. And the one of the key partners is an alum from this school who's disappointed that we've taken this position. And I feel sad when I hear that, but at the same time, here we are. And I think you agree with the position that we've taken, and I don't disagree that I'm just thinking out loud, but all that to say, so I remember asking Warner Chappell, like, can you just, because I wanted to feel better about it, can you just explain to me what your thinking is? And their answer made sense to me, like that sort of, just you can't be vulnerable to damages forever, right? And the thing that I learned from you, Professor Lind, which is that the fact of the matter is the infringement can continue. So, well, first of all, you don't get into court unless you've actually registered your work. So if you've already done that, you're aware that you have a copyright and that you can enforce it. Now we live in a worldwide internet age where, never mind the risks of AI, but you can just discover just about anything. And and then the infringement, like even if you missed the boat and the movie was already like what happened in in the Stars versus MGM case, where some employee who I hope got a bonus discovered the infringement happening with their films on Amazon, particularly one that started the discovery of all the others. Like, okay, so you're late to the party to discover, but that the infringement's ongoing, right? Every single time the work is distributed, the clock ticks again, starts, continues to tick, and you can tack on 3 years. So I guess with that in mind, it's not unreasonable to say we've got to put a cap on this, and you can't just have because I think it's very, very hard. The other thing that Warner Chappell explained is that it's really hard to prove that you should have known. Like, I mean, that's all. I'm just thinking out loud, but I think those are some of the things we're wrestling with.
So you're thinking out loud, and what I think I'd like to do is maybe just if you could roll your chair over there so people can see it while you're talking. Well, there may be other Q&As coming in, and Robert, I don't know if you want to weigh in yet or not, but okay. But
Robert should, Professor Lynn should weigh in.
Well, that's good. That way they can see you, because I think we may be off camera.
There.
Okay, and I don't know if you're able to navigate, see if there's a question from.
Are there any? Oh, this is a Lily, I don't know about CLE, it's not.
No.
Meaning that,
Oh.
there are no other
Oh,
questions. Yeah.
there's no other questions on the other side.
Professor Grimes seems to have one.
Yes, Professor Grimes.
So I teach the course called legislation, and so I'm interested in the legislative history argument. Let me make sure I understand this. There are two statutes to interpret here. One is statute of limitations in the Copyright Act, and the other is this more generalized statute that allows they're called the Discovery Act. I don't know what it's called, but
It's not, yeah, there's just the statute of limitations, and the statute of limitations, they can bring infringement at the time to which it accrues. So it doesn't specifically account for a discovery rule, but courts have continuously utilized the discovery rule.
Because the Copyright Act never says like in print, no discovery rule can apply here. People have read it into the act, even though the act on its terms, and by the way, considered, and this is one of the things we argued in the Petrella case, like it considered different periods of time for statute of limitations and spent a lot of time thinking about stuff, and it settled on 3 years.
so the discovery rule, is that based on the statute, or is that just a court interpretation of statute of limitations in general?
I think the latter. I mean, there's no like a specific.
So there's no.
And in the Ninth Circuit, the discovery rule, I think first came into being in the 90s in a case that starts with an R, I'm forgetting, the Rowley case. So that, but I don't, the discovery rule is something that is like applied in certain bodies of law, in tort, particularly in tort, right?
And a trust.
Yeah.
Yeah, and antitrust, there you go. But Robert Lind, I think you might, I don't know if you want to add anything, I don't want to put you on the spot, but.
Well, there's a specifically in the copyright statute, there is an express 3-year statute of limitations, but that goes to jurisdiction. So there's two issues when you're looking at whether you are bringing a case within the allotted time available to you. One is to make sure that the court has subject matter jurisdiction. It's a copyright infringement action. You have to be in federal court and you can go forward. There is nothing in the copyright statute that talks about how far back the damages will go. You know that it will go back at least 3 years. The question is, can it go back longer than that? And so many times it depends on when did you know that you had damages? When did you know there was an infringement? Copyright infringement is a tort. And so there are some common law notions that go along with it. And one of which the 7th and 11th Circuit had played around with but weren't consistent, is that when you're talking about a continuing series of infringements of the same work by the same defendant, that maybe the copyright courts, tribunals should be looking at this notion of a continuing tort. And so that hasn't caught on. So for the longest time now, before Petrella, the courts have had, and practitioners would understand that you have 3 years to bring a known infringement before a federal court. And at least here on the West Coast, it was pretty much understood, and you would tell clients that you can only go back 3 years. And if you don't have the damages within that past 3 years, then it's not economically worth going. In the Petrella case, which dealt with Raging Bull, which is never a big seller in terms of box office or even physical media, the reason that they brought the action in that case when they did is because MGM had decided to release an anniversary edition on Blu-ray of the film. And so that started the statute of limitations running again.
I guess what I'm still a bit unclear about is the discovery rule is almost common law. It's not statutory. So in effect, what you are arguing in your brief is you're saying that the legislative history of the copyright statute of limitations provision is relevant in interpreting common law, nothing wrong with doing that, but I just think it's very interesting, not the conventional use of legislative history.
Well, it's also that. Do you wanna say?
Go ahead.
I was just gonna say, because it's not that the Supreme Court has also weighed in though on saying, you know, it's very rarely appropriate to invoke the discovery rule when you're dealing with statutory law. So it's not in a vacuum that we looked at legislative history, and also that is exactly what we looked at when we argued no latches, like the statute is very specific, and the authors of it thought about different aspects of the law and remedy. And so in that way, it's to say this the statute should trump, you know, any other law that might muck it up. That's the argument. And I think you're making an interesting implied argument the other way.
Yeah, well, you know, if you look at the United States Supreme Court, there are people on the court, past and present, like Scalia, who said legislative history is bunk, because the only thing that's enacted is the statute. And so then using legislative history to influence interpretation of the common law, I don't know how.
Well, no, it's interpretation of also the intent of the actual infringement, right? The subject matter jurisdiction, it's not just in a vacuum, it's not disconnected, it's to say, there's this 3-year period, and it also means, by the way, I mean, the Second Circuit is sort of on its own and saying, yeah, we allow the discovery rule, but we still limit to 3 years. So you can come in and get your subject matter jurisdiction later in time if the discovery rule is appropriate. Meaning, right, if you can make a showing, but you still are limited on the discovery side, which means that they're also seeing it as a serious limitation.
And also, Warren, keep in mind that until 1978, there were 2 forms of copyright: state common law copyright for unpublished works and unregistered works. And then you had the statutory copyright, which is provided by federal statute. And so with copyright starting out, it was a common law notion. And so you have a body of law that talks about such things as what damages are available and latches and that sort of thing. And so now the question is, to what extent do those so the statute and interpretation of the statute focus on those common law beginnings? So it muddies it even more.
Well, I've in no sense suggesting that it was improper to use legislative history. I just think it's a very interesting case. Of course, you have Scalia is no longer around, but I think Gorsuch is still a disciple of Scalia on the legislative history issue. I always tell my students in class that if you have a chance to make a legislative history argument, by all means make it, because there'll be some members of the Supreme Court who will listen to it, even if a few of them won't. And Scalia, even though he would launch into diatribes against legislative history, was known to use it on occasion. Anyway.
Well, if nothing else, the argument is judges shouldn't be making up this law. It's not common law, right? We're dealing with actual statutory law in a very clear framework.
It really is an interpretation of the Copyright Act.
And
One other question, though, I sense that some of the Supreme Court's recent decisions have been somewhat hostile to broad readings of the Copyright Act. And I'm thinking of
Fair use cases.
yeah, well, yeah, in my antitrust treatise, I cite the case involving. I'm sorry, which one did you mention?
Oh, is Google the Oracle maybe, or I don't know which case.
Oracle, yeah, that's the one. Anyway, I just wonder whether you sense that that's going to play a role in this case. I suppose if the court were still hostile to broad interpretations of the act, they'd be more likely to want to limit your ability to bring an action.
I mean, their holding in Warhol was pretty specific, and of course the issue presented to them was narrow, so they stuck to it. Even the Petrella case deliberately went out of its way to like not address more than it needed to. Arguably, then it created confusion. So here we are, and maybe it's as simple as the Supreme Court sees the confusion it's an issue that's affecting creators, and it should just resolve it. Even if to say, Congress, if you meant something else, go figure it out. We
Okay,
need to tell Warner Chappell that we need to respond to them, actually, we haven't done that yet. We're.
well, we have to work out the
We decide,
logistics
yeah,
still on that, but yes, I think the current thinking is that the Amicus project is going to under the leadership of Christina is going to file a merits brief on these issues under the supervision of Professor Avid, and of course with any help that and counsel that our copyright guru Robert Lind is willing to solve.
Actually, I think it's worth, if you could explain to the students before we end, just like the parameters of an amicus brief, distinguishing it from a brief, by a party.
So, yeah, I think what we're talking about in the Amicus project, and I know there are a number of students here, and maybe you're here because you're thinking you might be interested in participating in the Amicus project. It is a it's a course. It's an academic course that students take for academic credit here at Southwestern. It's a 2-credit course called the Amicus Project Practicum, but it's an invitation-only course, and so students apply to actually be accepted into the Amicus project, which is a pro bono outreach program. That's what Christina did. And then what I do as a director is any number of things can happen. I try to and in fact, this is answering a question that we have in the chat, that is, how can we join the Amicus program? What I do is I will review all applications, such as Christina's, and if we look at academic excellence and also demonstrated commitment to public interest. All of our cases have some type of public interest component, as you can see, even on the copyright side of things, as in this case. And then I will try to identify, once we've identified a student and the student's interest and expertise, we'll try to match that student with a case and with a supervisor, and a supervisor is typically a professor here at Southwestern, but it doesn't have to be. It could be somebody who is a specialist and a practitioner privately. Although again, the cases all have that pro bono or public interest component or aspect to it. At that point, the student basically goes into thinking about the novel arguments to be made in this amicus brief. It's either going to be in support of an appellant or in support of a respondent. It could also atypically be in support of neither party. What our goal is in the amicus project is not to just repeat the arguments that party counsel would be making. Our goal is to try to educate or inform the bench to a novel argument, or something that was not necessarily addressed or not addressed sufficiently in the parties' briefs. And I think we did that quite well here. That's, so the amicus project does this in any court where we have somebody who can who is licensed to appear, and that includes the United States Supreme Court. And the majority of our cases have been merits cases, but we do from time to time take certiorari cases, petitions for cert. And then once the student completes the preparation, the research and preparation, drafting the brief in accordance with an established schedule, then the student actually will submit the brief for a grade, and that's the academic component. And then separately from that, the Amicus project will decide, well, we will file this brief. And I'm thrilled to say that that's always happened, that the professional accomplishment has always complemented the academic accomplishment, but they really are two different things. So you get graded, you know, and it's a letter grade, you know, you could get an A, and for reasons unrelated to your brief, it might not get filed. Maybe a case was mooted. They are separate considerations in the Amicus project. And I will say I was thrilled with the work that Christina did on this brief, both academically and I think professionally. Although I understand, as Professor Ravid has said, that, you know, choosing a side here can be fraught. I like the little guy too.
Professor Lind is closing his ears.
But I also, you know, understand that, you know, the law doesn't always favor the little guy.
Well, and if nothing else, the little guys or gal, as it were, will now be on notice. I mean, that's the other thing, is like there's plenty of artists who just don't even bother to be aware of their rights, and including whether termination rights, whatever. And it just, I think it behooves artists to be on notice, and organizations that work with artists should inform them, like, you need to, you know, pay attention and you need to enforce your rights. You can't just come late and do so. By the way, to speak, one of the other reasons I think we do legislative history arguments is that it's another way of covering territory argumentation that's not covered by the parties.
Okay, yes, and say your name,
My name's Phoebe.
Phoebe.
What is the selection process for the case that you?
What's the
The
selection?
Selection of case process.
So it can happen a number of different ways. My role's kind of like a matchmaker. You know, I have to have students who apply, and some years I'll get a good number of students, but they have to be they have to apply, and they have to have their applications accepted. And once I have a qualified student available in the program, then I've got to find a case that I think is the right case, and then I have to find supervisors. And you know, I'll participate in the supervision, but it's important to have somebody who really is a specialist in the area, like, for example, Professor Ravid and Professor Lind.
In reverse order, that's the real specialist, not just a sideshow.
Let the record show that she's pointing to Professor Lind. And then, you know, if all the stars align, Phoebe, then we're good to go, assuming that the timing works well for the case. And that's the other thing about the Amicus project. It's the only course in the course catalog here at Southwestern that is not geared to the academic calendar. It's geared to a court calendar. So you can actually start your project in May, and maybe it won't be ready until August. There's no drop ad deadline, for example. That can be a little fraught, because that means there's no drop possibility. And again, that's the way it works. You're working within a professional context, which is a court calendar. So it is, you know, a student can be tapped to take a case, for example, in November and finish it in February, and get their grade in February. So, yeah, I'm not sure if I answered your question sufficiently, but did I?
Yes.
Okay.
I mean, we could have Tina talk to her experience about being in the.
Yeah, would you like to hear from her what her experience? She alluded to it at the beginning, but I think I would love to turn it over to her. Maybe you can tell a little bit more about your whirlwind experience in the Amicus project. So I'm going to give her center stage.
Yeah, whirlwind is a good word for it. We had a very, very short time frame for this brief. Especially because the time it came about was right when finals was going on. So I was juggling 4 finals.
Spring
plus-
finals.
Plus gearing up for this brief. So literally, like, once finals was done, it was like all in on this brief with all the research, and then doing the outline and submitting that, having to do the first draft. submitting that, getting feedback, going through it. I had stacks and stacks and stacks of copies of the brief with red mark all over my apartment. And many sleepless nights. I think the gearing up to the, not that this is healthy and nobody should do this, but gearing up to when the brief was getting ready to be filed, I think I probably got like 8 hours of sleep the whole week, honestly. Lots of power naps. They do wonders. So, you know, but I mean, that's the thing. It's no different than I think really anything else in law school, you know, like you have a deadline, or even just like in life, like in the court, right? You have a deadline, you have to get it done. So you're going to make sure you do whatever to get it done. So,
Yeah, and I mean, I think the difference here is, and I think you hit it on the nail, Christina. I think the difference is that it really is a professional experience as much as it's an academic experience. So there's no extensions, right? Because court isn't going to grant you an extension. You know, you need to do the work. If the work product isn't there, then we're likely not going to file it. And if we did, a court could reject it. I think one of the reasons we've been so successful in the last decade is that we are very careful about who we bring into the project and how we supervise the brief. And it is a very elaborate process, especially at the Supreme Court level. There are 4 Supreme Court printers that you need to choose one and work with. And you have to get through the printer.
Right, the formatting is very specific.
So I mean, tell about your formatting experience.
it was interesting. It's like formatting to me is, I think, always the most frustrating thing. It's like Word never wants to work the way you want it to work. And but yeah, it took a while just to get the formatting.
And you're going back and forth between people on a Mac and people on another.
Yeah.
PC that it's also missing.
There was things like they'd be like, "Oh, this is off," and I really like couldn't see it. I'm like, I don't understand what you're talking about. So it's that whole process itself is time consuming. And I think that's the other thing is just like, you know, planning time to do like citations. You have to go through and make sure those are all correct. That takes time. Making sure all the formatting takes time. So you have to really plan and manage your time effectively. So.
And know that this is, I mean, if it's accepted by a court, your work product is public forever. Like right now, I search this case, I immediately see your name on the Supreme Court blog, you know.
Well, that's by design.
No, I know.
Right. I titled the brief with the student's name first, because that's how we look at it in the Amicus project. This is, we believe, your brief.
Well, you did all the work.
And your professional accomplishment. So it is the brief of Christina L. Cavazos. And it will always be known as that. And it will always be not only on the Supreme Court's website and in its archives as that, but it will also be on all the databases. When you do searches, it will show up. And so
it also means the position you take. I mean, aside from the professional integrity that will, you know, represent you in your career, it's also, I think, worth thinking through like the position you're arguing. If you'll ever live to regret, like, you know, you may not get a job at a certain person's plaintiff's firm, but that's okay. They don't hire that many people. But I mean, I think that's an important, I hate to say it, but it's an important consideration.
Well, this is the point where I say that, you know, remember, you're a lawyer. You can write a brief on behalf of clients where maybe you don't completely agree.
We actually have a
That's right.
discussion about this, like when discussing to do the brief and everything, because I, again, was more leaning towards like creatives. And, you know, Professor Epstein was like, what if the law doesn't come out that way? He's like, are you okay, you know, having to argue for the other side? And ultimately, I mean, that's your, like you said, your job as a lawyer is you have to like,
I mean,
you know.
you do the best you can. And yes, is it possible that maybe the law isn't supporting your position? Well, that is possible. And the other thing you have to keep in mind that, you know, in this case, yes, it does represent the signatory's position. They are above the line and below the line. Below the line meaning they're in the counsel field, although not you, Christina, of course, but the lawyers are in the counsel field, but they're also after following Christina's name in the amici field, which means it represents their view. A few things. I like to think we live in a world, one, where if you have an honest difference of opinion under the law, that you're not prevented from, applying for a job, and that they will look to see how, how good your work was, how professional you were, what your work product, the quality of your work product. I like to think that. And I also would like to think that it's very possible that at one point you may change your mind. People sometimes, their thinking on how they may interpret the law can evolve, or circumstances can lead to a change of heart. So I don't, I don't look at the fact that you have enshrined for posterity your view of the Copyright Act in this particular context as in any way somehow limiting your professional opportunities in the future. I would say quite the opposite. I think much more important to future employers is the fact that you're able to undertake a project like this and make the type of impression that you made with the faculty that you interacted with, and also, frankly, in terms of your work product with the court. It is not a given that that briefs are accepted by courts. Some briefs do not get accepted. Some briefs are returned, sometimes with stern comments from a clerk's office. I don't take it for granted when a brief is submitted. And that's why I'm very, very careful to make sure that our briefs are of high quality. And you made it easy because your brief was very high quality. Other questions? Yes, Professor Grimes.
I just want to add to what you're saying. I supervised 2 of these briefs, and every experience is totally different. Like one of them was to the US Supreme Court, one to the California Supreme Court, different issues, we had different people from the outside that were interested in our work. I wouldn't personally worry about getting a job based on the position you take. I don't think that's likely to be much of a factor. I agree with Professor Epstein that if you do good work, that's the most important thing. And it's an experience to work, because most briefs at a Supreme Court level, either California or US, are committee efforts in the sense that there are a lot of people that are working with you on it. I don't know whether that was your experience, but
No,
I think you're going to find. I just helped Josh do a brief, and we had an outside law firm and a retired state judge and a lot of people providing editing input, suggestions, and so it's one of the experiences of doing this kind of work is learning to work as a part of a team, and you end up being the major person that's responsible for it, but you're accepting input from a lot of different people. Anyway,
It's very much, in my view, it's like working in a law firm. And you've got, senior partners and junior partners, and you are the associate that ends up really mastering the issues. That's how I look at it. And I know you referred to Josh Kahn, who is here today, and he'll be doing a spotlight next semester on the case that he worked on under the direction of Professor Grimes. I would also want to just be clear that the Amicus project itself, it is content neutral, all right? It takes cases where I could basically match somebody with, you know, in terms of, again, their interest and a supervisor's interest. So there's an organic process here. It could have very well gone out the other way, and I know you mentioned that there was a plaintiff's law firm that expressed some concern about it, you know, and I would say to that firm, address the arguments.
I think
That's
they are.
right.
They're gonna
Address
be-
the argument, and if they want to do it in a brief, address the arguments in a brief. You know, that's why we do these amici briefs, these amicus curiae briefs, okay? Precisely because we're trying to make a legal argument, and if people don't like the illegal argument, the best thing to say is, well, maybe I should file an argument, and let's see what the court decides.
Yeah, and in the fair use cases, there were so many amici on both sides and, you know, people can have an intellectual, honest discussion. It's just at dinner, things can get a little dicey, that's all.
No, I
Okay.
understand, I understand. But that's the point with the amicus project. You know, there isn't a party line that you have to accept in order to take on a case. It depends on a number of factors. So we're almost at the end of our time.
The
I just
pizza,
wanted
who's
to-
where someone can find the pizza, they can eat it.
yeah, the pizza I think is in administrative services, and you can, on your way out, just grab a whole one. Okay?
Exactly. Whole pot.
But I do want to just give our principal producers of this brief, our supervisors, Orly Ravid and Robert Lynn, an opportunity just to weigh in with any final comment that you have. And then the last word is going to go to you, Christina. And maybe, you know, you can give us some insight, for example, on what you think the lasting impact of this might be as a case, and on you. So
I have nothing more to say.
so she's demurring.
I'm demurring again.
Robert?
Just the one thing that I would suggest that the goals of an amicus brief are very different from the goals of a brief on the merits that the court has already made a determination we're going to hear this case. And the goal of an amicus brief on a question of whether cert should be granted, your goal is to have 4 people weigh in and say, we want to hear this case. 4 out of the 9 justices have to say, we're interested in this case, let's accept it. And so for knowing that there are certain judges that have, or justices that have certain points of view on legislative history or any other question or issue, you can use that to your advantage to try to persuade them. I don't care which way you come out, but you should hear this case. And so that's what made this particular project different than one of the ways it was different than when you're dealing with something on the merits.
Christina?
I mean, as far as the impact of this case, I mean, I think it's gonna be hugely impactful. You know, whether or not the court decides like discovery rule is or is not applicable, how far back you can go in damages, can drastically change the way copyright litigation is done. So I think it's gonna be a very impactful case. And then as far as like impact on me, incredibly impactful. Honestly, I think this is probably one of the best things I've done at Southwestern, probably one of the things I'm most proud of. And I am very much looking forward to working on the merits brief, because it's just like another opportunity to get better. And Professor Lynn said it is going to be different. You know, now you have to like argue why the court should probably come out in this way and support it. So, yeah.
Right. Well, we're at the end of our hour. Thank you all very much. And